mass incarceration, overcriminalization, plea bargains. These are just a few of the issues swirling around the topic of criminal justice reform, and tonight we are so fortunate to have two legal experts to tackle this topic. Ashley Morgan is a Denver Deputy District Attorney who prosecutes felony cases. Clark Neily is the Vice President for Criminal Justice at the Cato Institute. He specializes in constitutional law, overcriminalization, and police accountability. Please help me welcome Ashley and Clark.
Well, thanks so much. It's a privilege and an honor to be here, and thanks for braving the weather and turning out. Hope we can treat you to an interesting, provocative discussion. I'm sure we can, and we're really looking forward to getting your questions. I thought I'd preface it by explaining, we actually have a pre-existing relationship. Ashley used to work for the public interest organization that I worked for. She was a summer law clerk there, and one of the best ones we ever had, clearly. But a fun story. Ashley was were you a 4-year scholarship swimmer at Stanford, All-American?
Yeah,
right?
I was a good swimmer a long time ago.
So I was a lifeguard, and I got it into my head that meant that I could probably swim faster than her. And then we were out drinking with some other law clerks one night. The more beers I had, the more certain I was that I could beat her in the pool. So we had a bet that night, and then fortunately, the next day, Ashley had some regrets about the bet because we hadn't made it interesting. There was nothing riding on it. We didn't bet anything. So she decided that she wanted to renegotiate, which we did.
I actually forgot what the stakes were because
there were none.
There still weren't. We never.
That's why you renegotiated the bet. So
I don't even know what I renegotiated to. I don't even remember.
I was the older and wily lawyer who, when I woke up the next morning, realized I was going to get humiliated in the pool. My sister was a scholarship swimmer too, so I know what they can do. So I was able to renegotiate the bet. I said, well, if you want to make it interesting, we can do that, but we're going to have to renegotiate the entire bet. What I managed to get was ultimately the bet was that the race was me against Ashley, but she couldn't use her arms. And it was very nearly
I only got one breath.
And one breath.
It was a 50-yard swim. He did beat me.
Barely.
It's one of the saddest moments of my life, but he barely beat me, but I did not use my arms.
So we have a lot of respect for each other, and we're used to sort of competing with one another. And it's interesting that we've gotten to this point. Neither one of us was particularly pointed in the direction of criminal justice at the time that we knew each other. And I have only been working in criminal justice reform for about the past 2.5 years. Before that, for most of my career, I was a constitutional litigator at a public interest law firm called the Institute for Justice. But in the course of doing some of the work there, including particularly civil forfeiture, which is a law enforcement technique that enables them to take your property by asserting that it was involved in some wrongdoing but not necessarily proving it, I began to have really serious concerns about the criminal justice system here in America. And the more I looked into it, the more concerned I became. And I'm going to share with you tonight a couple of what I think are my most serious concerns about the system, the aspects of the system that I think are most fundamentally problematic. I think there are lots of problems with the criminal justice system, but I think it's important to focus on the ones that seem to be most fundamental. So that's what I propose to do tonight. But before I dive in, anything you want to add?
Yeah, so like Clark was saying, I started at the Institute for Justice. That's where I was an intern while Clark was working there. And then afterwards, I was working in corporate law at New York. I did transactional work. I did general commercial litigation as well as criminal defense, more white-collar insider trading work where I was defending people that worked for companies against typically the federal government, indictments, things like that. Then I moved to Denver, and I was a civil litigator and did some criminal defense work as well while in Denver. And then I just decided I was very bored. I just did not really like this civil practice, and I almost left law entirely. And I decided, the criminal justice system it's important, and I had actually had a lot of intersections with that in my life. My mother was incarcerated when I was in high school. My sister has been incarcerated. She's 2 years younger than me, both federally and at the state level. When I was in college, I actually worked for the Southern Center for Human Rights, which goes into jails and prisons and looks at some of the ways inmates are treated, deals with death penalty issues, exonerations, things like that. So I'd always kind of had this in the back of my mind that maybe someday I would be there. And so ultimately, what I was doing was making a decision between, do I want to be a public defender? Do I want to be a prosecutor? And I thought really long and hard about this, and I talked with a lot of people about it. And given our skepticism for the power of government, I was a little bit scared to be a prosecutor, but I ultimately decided that that's where a lot of power lies, and that's where you can make a lot of change. And kind of, before we get into this long discussion about what's good and what's bad about the criminal justice system, I think one disservice that we are really doing is the more left-leaning and more libertarian-leaning people are demonizing prosecutors. And what ends up happening is, when you're in law school, you're taught public defenders are good and prosecutors are bad, and we're not getting prosecutors that want to make sure that constitutional rights are upheld. Luckily, I'm at a very progressive office in Denver where that's really important to prosecutors, but I'm sure you've seen in the news bad things that prosecutors do, bad things that police officers do. And I would say that one way that we can change the system is by making sure that we say, being a police officer, being a prosecutor is a good and important job, and we want to make sure that we have people that have the right values doing those sorts of jobs. And with that, we're going to hear how terrible I am.
So I want to preface my remarks by saying the following. I'm a libertarian. Unlike a lot of libertarians, I actually think it's really important to have a well-functioning criminal justice system. I think that's something the government should be doing. And I think it's incredibly important that the government do it well. I think there are people who have shown through their behavior that they are a threat to peaceful people. They will hurt other people. They will take your stuff. And so I want to say right up front that I personally believe that we do need a well-functioning criminal justice system. I even would go so far as to say I think there are some people who need to be taken out of society for a time so that the rest of us can go about our business and interact with each other peacefully and not hurt each other and not have to worry about being hurt by other people. But I think in order to be well-functioning, a criminal justice system has to do two fundamental things. First, it has to produce substantively fair results, and by that I mean it has to punish people who are truly deserving of punishment and do so fairly, do so appropriately, and leave other people alone, people who don't deserve to be punished. But second, it needs to do so in a way that is not only substantively fair, but it looks fair. It does it through procedural mechanisms that people can look at and say, yep, I feel confident in how that's being done. Whether it's done to me or a family member, or just somebody going into court and saying that they're doing it in my name, which is what prosecutors do. They go into court and they say, I'm here on behalf of the people of the state of Colorado or the people of the United States. They do it in our name. My big concern is I don't think that's happening. I think that we've crossed a very significant line. There's one particular thing that I think we're really doing wrong, and that I think deprives the system of its fundamental legitimacy. And I'm going to get into that in just one moment. One other thing I think is important for everybody in this room to know, and that is that America has the highest incarceration rate of any country in the world, and not by a little bit. We have an incarceration rate that is 3 or 4 times higher than similarly situated countries like Canada, Australia, and most European countries. And I'm not proud of that. I'm not remotely proud of that. Is it possible that Americans are the most criminal people in the world? It's possible. I don't like to think so, and I don't necessarily think that that is the case. I think that having the highest incarceration rate in the world is not something we should aspire to, and I think we can do better. I think we tend to use our criminal justice system as an extraordinarily blunt instrument. For example, did you know that the #1 mental health provider in America today is in fact the prison system? That's where we treat most people with mental illnesses. The same thing with drug problems. Our default response to people with drug problems is to lock them up. I'm not convinced that these are either moral or efficacious responses to those and other problems. So I think we overuse our criminal justice system for problems that probably would be better dealt with using some other means. Another issue, and I hate to break this to you if you didn't already know this, most of you are criminals. You haven't been convicted yet, but most of you have committed a crime, whether you know it or not. In some cases, some pretty serious ones. But let me take it off of you. Does anybody have teenagers? I know Claire does, because she mentioned it. Anybody else? Okay. Well, let's not get into your teenagers, because I'm sure they're wonderful straight-A students, but did you know that about 15% of teenagers in this country sext? Do you know what this is? It's sending racy pictures with your phone. If you're a teen, let's say that you have a 17-year-old who's in a relationship with another 17-year-old. It's a physical relationship. That's legal in every state. There's no state in the country where that is illegal. It's perfectly legal to do that. But if one of them takes an explicit picture with their phone, which I'm told is a thing these days, does anybody know what just happened? What just happened is the person who created that image has violated the federal law against the production of child pornography, because they've taken an explicit picture of a person under the age of 18. Does anybody know what the mandatory minimum for that crime that 17-year-old just committed is? It's 15 years. 15 years. Every time some teenager takes a picture of a 17 or younger year old person. It's a federal crime, and the only thing standing in between that teenager who took that picture and 15 years in prison is prosecutorial discretion. It's just totally up to the federal AUSAs or the U.S. attorneys in that jurisdiction. I understand, it's not my thing, but I understand we're in a state where some people enjoy a plant-based intoxicant, recently legalized in various parts of the country. I also assume that at least some of that material is produced in-state, locally. I don't know if anybody knows anybody who grows marijuana, but you might want to share with them that the federal government is not as enlightened on this policy. Does anybody know what the mandatory minimum for growing even one marijuana plant under federal law is? Because you should. It's 5 years, even one plant, you get caught growing it. You grow 1,000 or more plants, which my understanding is a pretty modest-sized grow operation for a commercial. You know what that mandatory minimum is under federal law for that? 10 years. Mandatory minimum. The range is 10 years to life for growing 1,000 or more marijuana plants. You can get on the wrong side of the criminal law in a hurry in this country. Now, one of the sort of the saving mechanisms, one of the things that's supposed to protect us from this, what I think is self-evidently overcriminalization, is that the Constitution makes it a relatively complicated, or means for it to be a relatively complicated process to move from the accusation of criminal behavior to the conviction and punishment. Does anybody know what the constitutionally prescribed mechanism for adjudicating criminal charges in this country is? Anybody? You know it, just say it. It's trial by jury. That's right. Article 3 of the Constitution says that the trial of all crimes shall be by jury, and the Sixth Amendment explicitly guarantees a right to a public and speedy trial. Does anybody know how most criminal cases are adjudicated today? It is not the jury trial. 95% of criminal convictions in America today come through plea bargains. In the federal system, it's even higher. It's more than 97%. And here in Colorado, which is covered by the 10th Circuit, which is a federal geographic region, it's actually above 99%. 99% of federal convictions in this jurisdiction come from guilty pleas. Those numbers are extraordinarily suspicious. Does anybody think that the same people who are out there running around committing crimes, the moment they get caught, they become this virtuous citizen that says, "Oh my goodness, you got me. I don't want to put you through the expense of a trial. I don't want to roll the dice and maybe get acquitted because the police officer doesn't show up or you guys break the chain of custody or whatever. I'm just going to go ahead. You got me," right? There's only one way that you get numbers like that. There's only one way that so many people confess their guilt instead of exercising the right to trial, in my judgment, and that's coercion. Coercion. Now, people who favor plea bargaining, and by the way, I'm not one of these people who thinks that plea bargaining is categorically illegitimate. I don't. What I'm concerned about specifically is coercive plea bargaining. And let me illustrate what coercive plea bargaining is using a 1978 Supreme Court case in which they effectively embraced and ratified coercive plea bargaining. It's a case called Bordenkircher v. Hayes out of Kentucky. Mr. Hayes was a small-time, let's just stipulate, kind of a punk, and he got caught doing some funny business with checks back when people used to write checks. And the prosecutor said to him, the punishment for this crime is 2 to 10 years. That's the range. I'm going to offer you 5. He said, I don't want to do it. I'm not going to plead guilty. I'm going to trial. The prosecutor said, well, let's think about that. if you don't take the 5 years that I'm offering, I'm going to go back to the grand jury and I'm going to re-indict you as a habitual offender because I know you've got 2 prior convictions. And if you go to trial after I re-indict you as a habitual offender, it's not 2 to 10 years anymore. You'll get mandatory life in prison if they convict. And that's exactly what happened. And that went to the U.S. Supreme Court, and the U.S. Supreme Court said, no problem. Now, does that sound like an inducement? Does that sound like a little bit of a discount if he just agrees to save the state the expense of a trial, or does that sound like coercion? And what you'll hear from a lot of prosecutors, and maybe from Ashley, is, well, we don't do that in my office. Well, I don't know anybody who's ever done that. Well, that may be, but a lot of people are out there doing it. Let me give you just 2 more examples. I'm working with a guy, and he has to remain anonymous because we're in litigation over this right now. Cato's trying to publish a book that he wrote, but there's a gag order. We're going to try and get rid of it. But this is a memoir about how this guy got railroaded by the federal government. He was an entrepreneur who started a cutting-edge business. The federal government misunderstood the nature of that business, prosecuted him and his partner. They were completely innocent. We've had 5 teams of people look at it. They all said, yeah, they weren't doing anything wrong. They threatened him with 200 years in prison. They charged him with fraud, conspiracy to commit fraud, everything you can think of. And they threatened him with 200 years in prison. After a series of cascading plea offers, the final, when they got on the eve of trial, and I think the prosecutors started getting a little bit nervous about whether they could prove their case, you know what they offered him? 21 months in a minimum security camp. They came down from 200 years to 21 months. But they still had the 200 years on the table. If you go to trial, we're still going for the full boat. And he and his business partner got together and they had the following conversation. The John Doe that I'm talking about, he had a young immigrant wife and he said, I can't leave her alone for the rest of her life. I can't risk leaving her alone the rest of her life. And his business partner had 2 little kids like I do. And he said, I can't risk letting my kids grow up without a father. They took the deal even though they knew they were innocent. Another example, and then I'll move on and wrap up. There was a man named Troy Mansfield in Texas. The story just broke earlier this year. He's been on the sex offender registry for 20 years because he was just messing around, having a pillow fight with his son, 5-year-old son, and a neighbor child. Neighbor child went home and said that he'd been touched inappropriately. There was a big investigation. They prosecuted Troy Mansfield, the one who was playing the pillow fight, and here's what they offered him. If you take the plea deal we're offering, you'll do 6 months, and you go on the sexual offender registry for the rest of your life. You don't take this plea offer, we're going to take it to trial and we're going to ask for 99 years. 99 years or 6 months. He took the 6 months, even though he knew he was innocent. Only earlier this year he was exonerated after they managed to get the prosecutor's notes that had been withheld for all these years, in which the prosecutors acknowledged that they never got the same story twice out of this child who reported the abuse. And one prosecutor's note on the margin even said, I don't believe there was anything that happened and we shouldn't take this case to trial. And that man was on the sex offender registry for 20 years and was finally exonerated. I have a real issue with that kind of plea bargaining because it is coercive. And there are no real safeguards. There's no judicially enforced safeguards. The only limits are essentially what individual prosecutors will or won't do in terms when it comes to deciding how much leverage to apply. And to wrap up, the big concern that I have is this. When the default expectation is that almost everybody will plead guilty eventually, because almost everybody does, then it raises a real question about when does the prosecutor stop applying leverage. They have a lot of leverage they can apply, all the way from pretrial detention to charge stacking to threatening with mandatory minimums like we talked about. And if the only question is how much an individual prosecutor is willing to do when it comes to applying that leverage, then there's no protection. And I'm not saying everybody who pleads guilty is innocent. I don't mean to suggest that, but we know that some were. We know that some people, innocent people, are coerced into pleading guilty. The final problem is this. It's not just the problem of coercion. When we use the constitutionally prescribed mechanism of adjudicating criminal charges, which is the jury trial, it makes society put its money where its mouth is. I asked a prosecutor friend of mine one time to estimate the cost of a felony prosecution, non-capital felony prosecution that included a jury trial. And I said, is it above $100,000? And he said, absolutely. I said, well, what about a plea bargain? Does that cost less than $10,000? And he said, oh, far less. So if it should cost us about $100,000 to take somebody's freedom away from them, but we're only willing to pay 10, doesn't that tell us that maybe we ought to think really hard about whether we really mean to take that person's freedom away? And if you're not willing to spend the right amount of money, if you're not willing to take a week or two off of work to go serve on a jury, to sit in judgment of that person, maybe we shouldn't be threatening to put him in a cage at all. Thank you.
So there's a lot to respond to there. I guess I'd first like to say that when Clark talks about prosecutorial misconduct, a prosecutor actually writing in the margins, I think this person is innocent, and hiding evidence from the defense, that is deplorable and something, there are protections against that. We have ethical codes that we have to follow, and if we aren't going to discover information, we have a duty here in Colorado and federally to provide the defendant with all of the exculpatory information that we have. The way that we do it in our offices, all the discovery we get, we disclose to the defendant himself if he's representing himself, which he rarely is, or to his attorney. I have had a few cases as a prosecutor that I have believed the person was innocent. I have dismissed those cases. When we have cases in our office where we think that police officers have not followed the law, when they've stopped someone, there wasn't reasonable suspicion or probable cause, or we thought we couldn't even prove our case beyond a reasonable doubt, we don't file them. So when Clark talks about these very extreme situations where there is definitely coercion when you're hiding evidence from someone, I couldn't be more in agreement that is improper, and we need to do everything that we can to make sure that that's not happening. That is not what is typically happening in state-level courts in Colorado. There are a lot of protections that defendants have in the plea bargaining process. The Constitution does not forbid plea bargaining. From my perspective, when I read the Constitution, is that it does not forbid it. A defendant does have a right to a trial. And there are protections to make sure that if he or she decides to waive that very important right, that he does so knowingly, intelligently, voluntarily, with advice of his counsel. So in my probably 400 felony cases that I've had in the last 2 years, have had 4 defendants that have represented themselves. 4. And 3 of them, by the time they pled, got the public defender back. I currently have 1 pro se defendant right now, and I'm hoping that that person will get an attorney, and I gently encourage it every time that I speak with that person. I am never interacting with a defendant one-on-one, ever. I rarely speak with defendants. I only speak with their attorneys unless their attorneys want us to speak together. That's an incredible protection. It's so important that a defendant has a right to an attorney, and they do have a right to an attorney, and we do not try to pierce that at all. That's something sacred. And it should be sacred, and I'm sure Clark has scenarios across this country, whether that's New York, federally, Mississippi, probably in Colorado, where this isn't being abided by, and that's a disgrace, and it should be upheld. But if we are following those rules, because there are ethical rules that we have to follow, we are not allowed to speak with the defendants when they're not represented. That is a protection in and of itself. They're not just being coerced by me to do something. I am speaking with their attorney, and their attorney is advising them to take this plea agreement. We're going to talk in a minute about why. Another protection is that anytime you enter into a plea agreement, it is a written agreement where the defendant says, I'm going to plead guilty to this crime, and this is what the sentence will be. Sometimes that's a stipulated sentence, meaning we agree on a number of years of probation, number of years or months of jail, number of years or months of prison, or it's open to the judge, and the judge makes that determination. In Colorado, the sentencing structures in federal law are incredibly complicated. In Colorado, they are somewhat complicated, but certainly more simple than federally. But the way that it generally works is that for felonies, we have 6 classes of felonies. Class 6 is the lowest. Class 1 is the highest. That is life imprisonment. That is murder. Class 6 felonies are what most of our felonies are, Class 4, 5, and 6 felonies. And that ranges anywhere from probation to 18 months if you're a Class 6 felony. And as you move up in classes, and the legislature contemplates that this means the crime is worse and a greater danger to society or a worse impact to society, that the sentence will move up with that. There are, of course, as Clark's talked about before, some implications if you have a prior criminal history. We have something in Colorado called the 2 prior felony rule. If you've committed a certain high-level felony before, as well as an additional one, and then you pick up another felony, you are ineligible for probation unless you enter into a plea agreement and the prosecutor decides to waive that rule, which happens constantly. Probation is definitely the norm right now in Colorado, or at least in Denver. We are largely seeing that most of our defendants are getting probation. Unfortunately, many of them are failing on probation and then having to go to prison or jail after that. Maybe we should be reforming our probation systems because, as Clark has discussed, a lot of the issues we have are addiction issues and mental health issues. And I'm in agreement that we need better avenues for that. We need a better mental health system in this country. It shouldn't be that jail is the option, and it is. But if you're a prosecutor and part of your duty is to protect the community, my only job isn't to protect defendants' rights, though I do believe that's part of my job. I truly do. Another part of my job is to make sure that victims are protected, that victims have a voice. How many people in here have been a victim of a crime? Not very many, right? We live in a different world. Every day when I walk into my office and I walk into my courtroom, it is a completely different world than what I am used to, because most criminals are in lower socioeconomic statuses than we are, and minorities. And you know what? That's exactly what the victims are too. And I think we forget about that a lot. So back to these protections. Anytime a defendant enters into a plea agreement, it is written what he's pleading to and what the potential consequences are. Included in that is an advisement that goes through all of the rights the defendant is giving up. The right to go to a jury trial and what that means. The standard of proof is incredibly high. In order for me to win in trial, I have to prove every element of the crime beyond a reasonable doubt. It's a very high standard. We often lose cases where we are certain that the defendant committed the crimes, but we just can't prove it because it's hard to prove. But a defendant, with his attorney's advice, is telling him it makes more sense to enter a plea agreement, and that's because very often we are allowing them to plead to lesser crimes than what they've committed. Our typical practice is if you've burglarized a house and it's a certain level of a felony, let's say it's a class 3 felony, we'll let you plead down to a class 4 attempted burglary of the house, which that in and of itself moves the entire sentencing range down. And what the defendant says is, wow, there's a lot of evidence. We live in an age now where we have cell phones. We know where people are. We can find where you actually were in that moment when we have your cell phone. We have surveillance, Halo, DNA, ballistics. The list is endless. We have a high burden, but we have a lot of evidence often that someone has committed a crime. And when that defendant and his attorney go into a room and look at all of that evidence, they say, yeah, the evidence is really good here. I would much rather not go to trial, be convicted of burglary when I can take the attempt burglary and maybe have an option at probation or an agreement. Is that coercion? I would argue not. There are a lot of protections there. Many more, there are times when we decide to take on massive amounts of debt, right? We go to college or we buy a home, and that can completely change your life. And you could maybe argue you should have an attorney for those types of decisions. An attorney is present through this whole process. That's a huge protection. In addition, a judge can decide not to accept a plea agreement. I've seen it happen multiple times, sometimes because it's too harsh, sometimes because it's too lenient. A judge will, so after this written advisement is signed, that written advisement is essentially orally presented in public in front of everyone in that courtroom. The judge goes through all the rights again. The judge says, are you doing this voluntarily? Are you taking drugs or a medication right now that could impair this? Are you happy with your lawyer? Has that prosecutor promised you anything in addition to this or threatened you in any way? All of these things are requested, and that attorney is standing there and supporting that defendant. And the judge has thousands and thousands of cases that he or she has seen over time and is making a determination about whether or not this particular individual is being treated fairly when she takes into consideration his or her criminal history and what exactly happened in this case and any other mitigating evidence that has been provided to her. And I say her because my judge is a she, and she's been on the bench for well over 20 years and has seen thousands and thousands of defendants. And something that she cares a lot about is making sure that they're all treated fairly. That, one of the horrible injustices would be if someone's committing a crime and has the exact same criminal history as someone else and is going away for 20 years when someone's getting probation. And a judge serves the function of making sure that there's equality over that. And we as prosecutors try to do that as well. There are a lot of benefits to taking a plea agreement. One of them is judicial economy. And what I mean by that is, and I kind of ran some numbers, so I have my notes up here. Right now, I currently have 92 felony cases. And in a year, I probably have somewhere between 250 or 300 cases that I touch. That's a lot of cases. I go to trial probably 8 to 10 times a year. The most I could probably go to trial without dying, just being working around the clock, and I have 2 small children and need to sleep, I would say would be 25 trials a year would be really hard. That'd be 2 trials a month. Some of them last a few days, some of them last a few weeks. If you kind of break those numbers down, and if Clark's position is every case should go to trial, I would, and it might not be, I would have to drop 90% of my docket. And in my 92 cases, I have 11 drug possessions, 12 dealing drugs or drugs with guns, 18 aggravated motor vehicle theft, pawn shop violations, thefts or trespass cases, 9 burglaries or robberies, 5 eludings or DUIs, 6 vehicular assaults or vehicular homicides, 2 human trafficking cases, 18 first and second degree assault cases, 2 sex assault cases, 2 aggravated robberies, it's a robbery where a gun or another weapon is involved, 4 attempt murders, 3 murders, and then we have other units that deal with economic crimes, all the domestic violence cases, child abuse cases, and sexual assaults on children. So my question is, which cases are we not going to file? What crimes don't matter? Because I can tell you that aggravated motor vehicle theft to the single mom that makes no money, that needs that car to get her kids to school and get to work, matters to her. And if we don't charge those crimes, they're going to increase. So if we're going to be in a system where most cases are going to trial, which it sounds like that's not what Clark's proposing, I don't know how we do that. Because there's if I were saying 90% of my cases were simple drug possession, maybe we should be having a different story. And maybe that's what's happening at the federal level, maybe. But I just don't know how we could do that. So judicial economy, that's the reason we have to plea bargain. We cannot afford it as a society, or we're going to have to get rid of some cases. It's also incredibly beneficial to a defendant. As I explained before, that defendant is making a calculation, and some people like to call this a trial tax. I think that depends on what your baseline is. If you've committed certain crimes, and you, the people, have told the legislature what you want, I don't make the laws. It's really important that I don't make the laws, because my job is to enforce the laws. The legislature's made these laws, and if we don't like these laws, we need to get rid of them. Because I go under oath and tell the people of Colorado that I am going to uphold the laws, because the people have told me that that's what's important to them. So I don't see the coerciveness that Clark's talking about. I know that there are instances where that's happening. You see it in the news, but I don't believe that that is what is typically happening. Of course, there can be tweaks to our system, but I don't think that the plea bargaining process is inherently coercive to defendants, and frankly, I think it's actually beneficial. And I don't know, and if there are any public defenders in this room or defense attorneys, I would love your position, because I don't see them advocating for it either, because I don't think it would be good for their clients.
Well, she's so good at her job. I think we'll have maybe 5 or 10 minutes of back and forth, and then we'd love to take your questions. But I think there's some really important points that maybe we can air with each other that will help further enlighten our positions. So I think you're exactly right about the concern that if we, completely eliminate. First of all, I don't think you can completely eliminate plea bargaining. It's been tried, and it just sneaks back in the back door. I may be libertarian, but I'm not, completely out of touch with the entire world. So we have to be pragmatic about it, and I do recognize that trials are very resource intensive, and prosecutors would have to decline a lot of cases. Now, I happen to think they probably should be declining more cases than they do. Some of you may recall that the federal government prosecuted a man named Scott Warren in Arizona for leaving water in the desert for human beings, some of whom happen to have been here illegally, but they prosecuted him not once but twice. They had a hung jury the first time, and then the second jury finally acquitted, even though he's probably guilty. I think that was good information, frankly, for those prosecutors to get. don't prosecute this man. That's ridiculous. Go find a real criminal. Anyway, but what I would propose is a pretty significant alteration of the system, not in an attempt to try to eliminate plea bargaining, but in an attempt to try to drive down the amount of it and also to change the quality of it. And it's a very simple proposal. It's 2 steps. The first thing I would do is go back to what I call a founding era informed jury. The biggest difference between juries at the founding era and for hundreds of years of Anglo-American history before that and current juries is that juries during the founding era, they knew what the consequences would be for the defendant if they voted to convict, and sometimes they chose not to convict a guilty defendant because they felt it would be unfair. Back then, a lot of crimes were capital, even some property crimes, and if they felt that it would be unfair to convict somebody for a particular crime, they just wouldn't do it. It's impossible to do that, to play that function if you don't know what the punishment will be. And I'll give you an example in real life. Cato submitted a friend of the court brief in a federal appellate court last year, where a man was being prosecuted under that statute I mentioned earlier, the production of child pornography, because he was in a relationship with a teenage girl. He took a picture. He was prosecuted both by the state and the federal government. The feds went and looked in his Google Drive, and they found a couple of these pictures. He never sent them to anybody. He didn't share them with her. No one ever saw them except for him and the prosecutors. But just by the act of taking those pictures, he committed that crime of production of child pornography. His attorney felt that the law was being abused, and it turned out so did the judge. And so his attorney said to the judge, I would like the jury to know that this man will go to prison for 15 years if they convict him. And the prosecution went completely bonkers. They were adamant that the jury not be told this information, even though it's public information. It is the avowed sentencing policy of the United States government. Anybody in this room could go and find out that mandatory minimum in 30 seconds on the internet. But these prosecutors were desperate to ensure that these jurors not know what would happen to this defendant if they voted to convict. And I think that's a real tell. I think if you're a prosecutor and you feel like you can't make both the factual case for guilt and the moral case for the punishment that you propose to inflict, that should tell you something. That should tell you something. The second change, I would propose that juries be told what the consequences will be for the defendant if they convict, so that they can play this long-standing role that they have played up until relatively recently in our history of acquitting factually guilty defendants if they think it would be unjust to convict, exactly the way the jury did with Scott Warren in Arizona.
Clark, can I ask you one question?
Yep, of course, yes.
Do you also think that juries should be involved in the sentencing, or no?
I think I'm sort of I have less strong feelings about that. I think that I think it's important that they either participate directly in sentencing, as they do in Texas and a handful of other states, or that they at least be told what the consequences will be for the defendant. Not just the punishment, the formal punishment, but also collateral consequences. So for example, a lot of people don't realize if you convict somebody who's not a US citizen, they will almost certainly be deported once they've served their sentence. That's a consequence I think people should know about. The other one, and this I think, Ashley, you'll probably find this a little bit more radical, is I think whenever anybody proposes to introduce a shortcut into a very complex system with lots of perils, lots of dangers, and very complex procedures that have been worked out to try to avoid or mitigate that danger. Take, for example, flying a commercial aircraft, which is a very dangerous thing to do if you don't do it right. If somebody proposed a shortcut saying, it would be so much more efficient if we didn't have co-pilots. Well, yep, probably would be actually more efficient. I wouldn't particularly care to fly on that plane. But so you can think of all kinds of ways that we can make things more efficient, the way we make the process of adjudicating criminal charges more efficient with plea bargaining. My argument is that any time someone proposes to make a highly risky situation more efficient by taking shortcuts like plea bargaining, the person proposing to do that shortcutting has to have skin in the game. So if a commercial crab fishing captain says, we should be going out in December because there's nobody else out there. Oh, I know it's the most dangerous month of the year to be out on the Bering Sea, but we should go out and fish because we'll get so many more crabs. You know what, buddy? You better be on that boat when it goes out, not just some crew, not just some schmucks that you're sending out there. What I propose to do is to require prosecutors to put some skin in the game. If they want to take the plea bargaining shortcut, they have to put personal skin in the game, and here's what I'd propose. If you as a prosecutor participate in or obtain a conviction through a plea bargain, and that person is later exonerated, and that happens actually with some regularity. We absolutely know that some people falsely plead guilty to crimes they did not commit. My proposal is that if you're the prosecutor who took a guilty plea from someone who later turns out to be innocent, you're disbarred for the rest of your life. You never practice law again. That way, people will focus their attention. And I believe that there are some times when the prosecutor is certain enough. The evidence is just like Ashley described. It goes from one end of the conference table to the other, and there's no doubt in the world. And I'll bet many prosecutors would say, you bet I'll risk my career. I know you did it, and I know you'll never be exonerated. So, yep, we're doing the guilty plea. But there are shakier cases. There are cases where, for example, some of you may have heard that Amy Klobuchar is now getting a lot of criticism because she participated in the conviction of a young black teenager in Minnesota, and almost the entire prosecution case was based on the testimony of snitches. Snitch is a technical legal term meaning somebody who's been bribed for their testimony with basically a reduction in sentence. Their charges have been dismissed, or otherwise they've been promised something by the prosecution. By the way, no other lawyers besides prosecutors are allowed to bribe witnesses because it produces unreliable testimony, and everybody knows it. So I would say in a case like that, I could imagine a prosecutor saying, I'm not going to risk my career on this one, we're going to trial. Because if the conviction is obtained through trial, that would be a safe harbor for the prosecutor. Why? Because you didn't try to shortcut the process. You took it through the constitutionally prescribed mechanism of a jury trial, you're safe. But if you want a shortcut, if you want to take this risky, sort of efficiency-promoting, I would say sort of constitution-winking approach, okay, but you put some skin in the game so that we know you're absolutely sure that when you take a plea, you know to a certainty in your own mind that that person was guilty. And if you're not certain enough to risk your career, then you're not certain enough to risk that person's freedom. Don't take that guilty plea. You're not confident enough. Reaction?
I mean, I think my personal reaction is, I think studies show that, and I don't think any of us can rely on statistics, right? Like, you can make numbers say whatever
Depends
you
whether
want
they're
them
in your
to say.
favor, I think, technically.
But I think people believe it's somewhere between like 0.5% to 1% of cases are innocent people, which to me is alarming, right? Because I've touched 1,000 cases if I include my misdemeanor time. And that's concerning to me, right? Like, I don't ever want it to be the case that I convicted someone that was innocent. That would kill me if I knew that. You want prosecutors that feel that way. I guess my only reluctance to that, the disbarring, would be if the evidence was really strong and it was just some fluke. I think if there's any malintent there, or any hiding of anything, or taking a risk that you shouldn't. I mean, frankly, if you don't believe you can prove a case beyond a reasonable doubt anyway, which is a really high standard, you shouldn't be proceeding forward on the case. That's my personal opinion and the opinion of our office. I mean, maybe I could get there with something like that, because honestly, the thought of someone going away is a terrible thing. I think the only way to ensure that no innocent person is convicted is getting rid of our criminal justice system, which is sad, but I think true.
No, I agree with that. It's a risk we have to take.
It's sad. I do believe that, I mean, we know that there are innocent people that have been incarcerated, and I think, I don't know what the levels show compared to felonies or misdemeanors or anything like that, but there are times, especially in misdemeanor world, where defendants come in, they don't want an attorney, they're just going to take it because they don't really want to deal with the whole process.
Yep.
And that's why it's really important at the time you file a case that you feel very confident that the person did it, just morally, but also beyond a reasonable doubt that you'd be able to prove it. If we were doing that, and I know it's not always being done, but I think if we were doing that, we would be in a much better place. So I guess that's my cop-out reaction.
And this is kind of a kumbaya moment, because I'm ready to meet you halfway too. And I think my radical proposal is permanent disbarment. And I think what I actually probably really mean is something more like a court-martial in the Navy. So every Navy in the world, basically, if you're a captain of a ship and you lose that ship or you run it aground, you're going to be court-martialed. And that doesn't mean you're going to lose your career, but you're going to be put in a position where you have to explain, how did that happen? That's not supposed to happen. So maybe I'd propose something like that, where there's a presumption that that should not have happened, and it's on you to show that it was some unavoidable fluke or something like that.
I actually don't think I would have a problem with that.
And what about founding era-informed juries? How do you feel about that?
So that is a really interesting area, and Clark and I have talked about this concept before, and when he first brought this up to me, my initial reaction was absolutely not. And not for the nefarious reason that Clark was suggesting, which is, oh my gosh, I can't let the jury know that because then I'll lose. The way that we are taught in Colorado, and what our judges care about, and what our public defenders also care about, is Juries are fact finders. That is their job. At least what our position is on this. Clark might say that that's not just what their job is.
He would.
We want to make sure that we have, 12 people that are taking times out of their life to come in. They don't know. Most of them don't know anything about the criminal justice system. They don't know what the sentencing structures are. They didn't even know that this crime was called this thing, right? It's complicated. When I came in as a prosecutor, I had no idea what I was doing, and I was a lawyer for 5 years before that. It is incredibly complicated. So one thing is you do have to keep things simple, and it's not because jurors are stupid, it's just because this is super complicated. So their job, in my eyes, and in most judges and public defenders that I've talked to, their eyes is, you have a crime. Let's say it's a robbery. That's taking something by force. I have to prove that on that date, in the state of Colorado, that person took this thing and used force. I have to prove each of those elements beyond a reasonable doubt, and the jury's job is to look at the facts, only the facts, and make that determination. Now, there are some things the jury shouldn't get to know, and I think Clark and I would agree about this. The jury shouldn't know what a defendant's criminal history is, because they might say, oh, well, that person probably robbed this time because he's already done it 6 times. Yeah, we as humans know maybe that is more likely, but that's not what their role is in that moment. Their role in that moment is to take the facts that have been presented to them and determine whether we met our burden. Not whether they think the defendant maybe had done it, but whether we proved it beyond a reasonable doubt. So I think that when you bring in what the potential consequences could be, you're really muddying the waters. Because like I explained before, if you're charged with a Class 6 felony and you've had 2 prior felonies, your sentencing range is different. Does the jury get to know why your sentencing range is different? Because then all of a sudden, inadmissible evidence has to be presented to the jury if we want it to be transparent. Another thing in Colorado is if you're on bond or parole or probation when you commit a crime, your sentencing range increases. It typically doubles. So if you normally commit a crime and the range is probation to 18 months, but you were on parole or probation when you did it, so now the crime is probation to 3 years, do you just tell the jury, well, for this particular crime, he could get probation, or he could do 6 months to 18 months in prison, or he could do this amount of jail time. However, because he's already committed this crime before, or he was on parole or bond, here are the things that could happen. Can you imagine their heads exploding and not completely understanding what's happening? And I'm assuming Clark's going to say, just tell him the number, but that's not justice, that's not fair, and that's not transparent. With regard to a jury actually being involved in sentencing, I think that's a really bad idea, and I think Texas is the perfect example. We have a young, pretty, blonde, off-duty cop killing an unarmed black man in his home and only getting 10 years for that. A judge in Colorado would not have done that. I think a judge in Colorado would have said, I have to compare you to similarly situated defendants, and because I've done this so many times, and I know what is at least the norm as to what's fair and not fair, I am going to try to make sure that I am sentencing fairly. A jury might be swayed by emotion, by how pretty someone is, whether you don't like the person because of their race. And I think giving them the power to sentence, it's asking too much of a jury, and it's...
Yeah, to be clear, I don't advocate it, but
Yeah.
I think that a jury that doesn't know what the consequences will be for the defendant if they convict is a very recent invention and is radically inconsistent with 800 years of Anglo-American history. I think they had it right and we have it wrong.
Do you think they should know why?
I think it gets, I agree with you that it can get very complicated, but my baseline would be that a jury that doesn't know what the consequences will be for the defendant if they convict is unable to exercise its most important function throughout all of our relevant history, which is to prevent injustice. And not everybody who's guilty of a crime should go to prison for it. I think
Sure.
we can both agree with that. Do you want to?
No, I think probably everyone in this room agrees with it. There's so many different types of crimes, and we hope that we can use probation or other incentives to make sure that that person doesn't commit a crime again. I think that I know that both you and I feel that if we could keep everyone out of prison, that's what I would want to do. That maybe that would mean I wouldn't have a job. That's not what I care about. I care about making sure that, because the government has a lot of power. It does. And that was something I was really skeptical about. I'm very lucky because I work in Colorado where marijuana is legal, and I don't have to prosecute those crimes. I feel conflicted about some of our drug laws, like minor possession laws of heroin and things like that. In Colorado, it has just been made a new law that actually goes into effect in March, that if you're in possession of Schedule I and Schedule II drugs, it used to be a felony, it is now a misdemeanor. So the people are actually speaking and saying, we don't want this to be a felony. And I guess I would propose that the legislature is where a lot of these problems need to be addressed. Prosecutors are going to have discretion in either Clark's plea bargaining world, lack of plea bargaining world, or plea bargaining world. The question then just becomes, what do we charge? So the real power lies in the hands of the people, and we need to make sure that we don't have laws on the books that are ridiculous. And I think I can stop there.
All right, so we're looking forward to hearing your questions, and thank you for listening to us, but we hope to be responsive to your questions. Anybody have a question? Does anybody? Yep. Oh, yep, they do. All right. I saw this hand go up by a nose first, so do you want
to? One thing neither one of you mentioned is racial bias of the criminal system, which, although I was a trial attorney, I never touched a criminal case. But from what I read, the sentencing guideline, or not sentencing guidelines, the actual sentence, from police stops for no reason to sentencing is racially biased. And do you see that same bias in plea bargaining?
So I use the term racially disparate because bias implies that it's illegitimate, for example, that the racially disparate numbers are illegitimate. I think sometimes they are and sometimes they may not be. But the short answer is yes. We see racial disparities throughout the criminal justice system. We see it in the number of traffic stops, the number of times people are asked to consent to a search. That's disparate. And it goes right up, and there's even a study that came out last year that indicated that minorities, particularly black and brown people, get systematically worse plea offers than white people. Now, did they control for enough factors? I don't know. Did they control completely for criminal history? Did they control completely for the aggravated nature of the crime, et cetera, et cetera? I can't vouch for that study, but it was done by careful people who I think would have taken those things into consideration. They are not stupid. But the fundamental premise, is our system persistently racially disparate in the way that it operates? I don't think anybody can argue with that. The question is that, at least in some cases, justifiable or not justifiable? I think that's where it gets a little bit harder. So to just take one example, we prosecute black people disproportionately for homicides. It actually turns out that black people are disproportionately the victims of homicides, and it appears that their attackers are disproportionately of their own race. That's typically how it is, by the way. People tend to attack people within their own racial group. So that's a racially disparate statistic, but is it an illegitimate one? Does it reflect bias? I think that's a different question. Does that make sense?
And I would agree with Clark there. I think all of us, I know Clark and I would hope that we aren't making decisions based on race. I think that's something that I try to be really self-conscious about as a prosecutor. But we all have inherent biases. And with regard, I think part of what Clark was getting at is a lot of the crime that we're having and a lot of the police presence is in lower socioeconomic areas, which are disproportionately comprised of minority defendants and victims. And there are large systemic issues that have made that happen. I don't think there's any doubt that those groups are charged with, convicted of crimes at a higher rate, and I don't know if anyone has pinpointed exactly why and knows how to fix that problem.
Let me just add one more thing, if I may. So I do favor ending the drug war. I think it's been a failure, and I don't think it really accomplishes what it tells us that it sets out to. I have a secret plan for ending the drug war, by the way, and it would be this. If I were the president, I would instruct the Department of Justice to enforce our nation's drug laws with the same vigor on college campuses that they do in inner cities. And I believe the drug war would end within months. Why? Because we have, for whatever reason, the stomach to put away the sons and the daughters and the mothers and the fathers of the inner city for decades in prison for drug crimes. I'm quite confident we don't have the stomach to put away the sons and the daughters of doctors, lawyers, and senators. And if we started doing that, we would take a very fresh look at that policy, in my opinion. And I think even if it's not an overtly racial thing, if you're going to enforce a fundamentally unjust policy, which I think we do when we enforce simple possession drug laws, things like that, you want to make sure that you target a marginal group, a politically disenfranchised group, because if you go around targeting politically efficacious groups, they're going to push right back. So if you're going to enforce a fundamentally unjust policy, make sure you pick a politically marginalized group, and I think that's exactly what we do.
So just 2 points on that. I think a lot of what Clark just said is very true. One reason that brown people in lower socioeconomic status groups are being prosecuted for drug possession is because they're often homeless and they're out there, right? That rich kid who has a heroin problem, mom and dad are trying their best to figure that problem out. That's not fair, right? It's not. I think we agree there. I think one other point is I have had so many lately. We have a serious drug problem in this country. I think everyone's in agreement on that. The heroin problem right now, the meth problem right now is out of control, and it is out of control in white communities, black communities, Hispanic communities, everywhere. More and more often, I am getting letters from parents of defendants begging me to put their kid in jail. They're begging because they don't want their child to die. So we're in a position right now where we have to do something. And right now, the only recourse we have is jail. Do I think that's the best option? No, but that's what we have. So again, this comes to the people. We need to be willing to invest more money in drug rehabilitation. And Europe has done it and is doing better than we are. I don't know, why we aren't moving in that direction, but we need to, because that's all these people have right now is the hope that we can just take their kids out of commission for a little while so they don't kill themselves.
You had a question, and then we'll go back to the
Just
other
a
side
simple
there.
one, I think. No, I think I might have forgotten it. One thing I've seen that's been heartbreaking to me, is the number of people that have been involved in vehicular homicide that have had previous DUI convictions. What do you see here, and what does plea bargaining have to do with keeping dangerous drivers on the road?
I think that's a really good question. When I became a prosecutor, I thought the cases that would affect me the most would be the child abuse cases, the sex assault cases. But honestly, the cases that have most emotionally affected me are the vehicular homicide cases that I'm seeing. They can happen to anyone, right? And so, you could be walking down the street at the wrong time when someone's drinking and driving, and you're done. It doesn't, and I think that's the white privilege that I have, right? I don't live in the inner city where I'm getting shot at every day. I don't live in the place where I feel like my husband or my uncle is sexually abusing my child, which is happening in places where there isn't as much transparency, isn't as much money, and it's heartbreaking. But these vehicular homicides, they're a really serious problem. We have a DUI problem, and we now in Colorado, if you pick up your 4th DUI, it's now a felony. It's 4th. Your first 3 are only misdemeanors. The first one, people are typically getting probation. Then there are minimums of how much jail time you need to do as that kind of scales up. Vehicular homicides and assaults are obviously felonies. But the sentencing ranges on them are very interesting. If you commit a vehicular homicide because you're driving recklessly, then your class of felony is a class 4 felony, which isn't that high, and you're not looking at that much jail time. It's up to 6 years. So you could kill someone, but your mental state is not the same, obviously, as pointing a gun at someone, right? It's like you were going 90 miles an hour when you shouldn't have been, which is terrible, but or 70 miles an hour when you shouldn't have been. Then there's class 3 vehicular homicides, which are when you're under the influence of drugs or alcohol, or if you leave the scene of an accident where you have killed someone. And those ranges are not much higher. They only go up to 12 years. So you can kill someone, and it can be your 10th DUI, and you're not looking at a lot of time. And we have started experimenting only in cases that we think very much deserve it. of charging extreme indifference murder in these cases, which is a class 1 felony, which means that if you get convicted of it, you go to prison for the rest of your life. We have only done a few of these in Denver over the last few years. We only do them in situations where people have prior DUIs. They should have known they shouldn't have been doing this, and their conduct is absolutely outrageous. We're talking driving 90 miles an hour in a 30 with all the drugs you can imagine, running a red light, right? And we are starting to try to prosecute at a higher level. But again, I think this is a legislature problem, right? I don't think that we have the right sentencing ranges for that type of crime.
It's horrible. It's a tragedy. And the only thing I would add is that human nature is what it is, even if we wish it were otherwise. And I say that because there's a lot of evidence that increasing the punishment that someone will receive for certain conduct doesn't really seem to change behavior. People just really can't conceive of the difference between being in prison for 2 or 3 years versus 15 or 20 years. It seems to make absolutely no difference. And so there's this idea that, if there's a problem, we just need to ratchet up the punishment, right? If people are continuing to do this thing, like vehicular homicides, driving when they're drunk, in the face of a 1 year or 2 year threat of a punishment, then we need to ratchet it up to 10 and surely they'll stop. And unfortunately, no, so I think there are better and worse ways to try to deter this behavior. All I'm making is the very discrete point that as much as we might wish and hope that ratcheting up the punishment would make people respond accordingly, there's a mountain of evidence that suggests that in fact it doesn't. And if you really want to minimize the amount of this horrible, tragic, conduct, unfortunately, I think you have to look somewhere. You don't have to, but if you really want to change the behavior, you should at least be honest with yourself about the mountain of empirical evidence that suggests that increasing punishment doesn't really change anything.
Can you repeat what she said? Nobody can hear that.
So she said it's not about changing behavior, but protecting the innocent. And I'm not sure those are necessarily different. It may be that you feel like that person morally deserves to be punished. That's a separate discussion. Fine. But all I'm saying is be clear that that's what you're doing. Because if you ratchet up the punishments, don't fool yourself into thinking that you're going to get a big change in behavior, because empirically speaking, it appears certain that you will not.
So I think what she's getting at is, right, there are a lot of reasons why we have punishment in the criminal justice system. One is deterrence, which is what Clark's talking about, and I think a lot of the studies show that criminals don't say, I could go away for the rest of my life. Maybe I shouldn't kill this person, right? Like that,
or maybe I shouldn't drive drunk.
Maybe I shouldn't drive drunk. But the other things that the system is supposed to address is, and I think your point here is keeping them off the street. Look, if you can't learn, it's your 4th, 5th time behind the wheel, and you're acting like this and putting everyone at risk, you're literally a ton bullet shooting down a street at people, then maybe you need to be out of the society for a while. That is one.
Yeah, no, that's called incapacitation. A very good point.
And if your child were the one that were killed in this accident, if you didn't believe that the criminal justice system was doing its job, you might want to take revenge, matters into your own hands, and we don't want that, right? We don't want a self-help society where now we have everyone enacting their own revenge, right? We need to make sure our punishments are enough.
Yeah, I agree.
So I think there's kind of a lot that goes into that.
Thanks for that question.
Concerning plea bargaining versus trial by jury, isn't a lot of that decision based on money? Does the defendant have the money to hire a lawyer, go through the trial system? That would cost a lot of money. And the same thing that I think would be true with probation. Could it be true that a lot of people run away from probation because they can't afford to pay the court system, and they can't get a job because they're felons? So that stops them right there. They don't have the money.
Well, I'll take the first part of that. I think Ashley's probably better for the second part. So it's a very astute question, I think, actually. And there's some evidence that, so about 80% of the people who go through our criminal justice system have a government-funded lawyer, either a public defender or a private practice lawyer who's being paid by the government to represent them. And there is some evidence that people who have the money to retain their own lawyer, in other words, it's a lawyer that they have hired and they are paying, actually plead guilty at a lower rate than people who have a public defender. And there are some jurisdictions where the public defenders are so overworked that everybody knows that they can't take more than a small handful of their cases to trial, and everybody knows their true role is simply to negotiate the plea. And it can even, I've even talked to some of my friends who are public defenders, that it can even get to be the case where if you're a public defender in some jurisdictions and you are too zealous in your representation, if you're filing motions and you're trying to suppress evidence and so forth and so on, and you get a bad reputation with prosecutors as somebody who's kind of gumming up the works, your clients start to get worse and worse offers until you get the message to play ball. And in a system like that, and I'm not saying that happens here, but I'm saying it happens in other places. In a system like that, then rational defendants will, of course, end up feeling like they're just going to have to plead guilty because they're represented by a lawyer who really doesn't have time to give them a fully zealous representation, and a plea is the only way to resolve that case. I think nobody should be put in that position, but we've made certain funding choices that ensure that people who are able to pay for their own lawyers are oftentimes, not always, but oftentimes getting a far higher class of advocacy than people who are getting a government paid for lawyer. I mean, it's the difference between FedEx and the post office. Sorry if you like the post office, but.
So obviously I can only speak from my perspective, right? I can't talk about what's happening in every jurisdiction. I will say that the public defenders in Colorado are really good, and often we respect, and I wouldn't say I'm afraid to go to trial against anyone. Like, trial in and of itself is a scary thing. It's a performance art. There's a lot on the line, whatever, but some of those public defenders are incredible. They've been doing this for a long time. They're not afraid to go to trial. I would be totally on board with making sure that prosecutors and public defenders made the same amount of money. I think that's a good way to move forward on that. We don't make much money. They make less money. We should be making the same money. I would completely advocate for that. If you can't afford attorney, you get a public defender or you get alternate defense counsel if there's some sort of conflict. Clark just mentioned a statistic of 80%. I would say in the felony world and what my practice is, I've told you I've had 4 people that haven't had a lawyer and 3 of them got them back. I only have 1 currently. They almost all have attorneys. And public defenders are overworked. Prosecutors are also overworked. We have larger caseloads than public defenders have, obviously, because we're the ones filing all of the cases, so we have all of them. But in any way that we can try to even that out to make sure that public defenders are getting paid and compensated and incentivized to be public defenders, I think that's a good thing that we should do.
Yeah. Other questions?
We're very grateful for your appearance and your candor. My question is, would you two please address the ongoing controversy about bail and if you have any recommendations on how to make it more fair?
Bail's a complicated issue. We all know what's happening in New York and has happened in New Jersey and other places. In Colorado, that we are not that extreme, but there have been bail reforms, and our judges are very often giving what we call PR bonds, or personal recognizance bonds. That's when you don't actually have to put up any money at the front end, and so if you're poor, you get out right away. The way that bond arguments work in Colorado is when you get charged, you appear for a first advisement. At that first advisement, that's when the judge sets the bond. The public defender or defense attorney will say, hey, this person should get a PR bond, or this person should get a low cash bond, or whatever argument. The prosecutor will then say, no, this person has 5 prior felonies, a few of them are recent, he picked up this current case while he's on probation, it's a high-level crime, that person shouldn't get a personal recognizance bond. Or we might say, yeah, we agree. This person has a very minimal criminal history. This is just drug possession or an aggravated motor vehicle theft or a lower level crime, and we're in agreement on that. Judges are very often giving personal recognizance bonds in Colorado unless we're seeing violent crimes, sexual assaults, or people who have repeatedly violated the law and been convicted.
I agree with Ashley. It's an incredibly difficult and challenging question, right? Because we want to make sure that society is protected, but we also want to make sure that the rights of the accused are protected. I would just make a couple of points. Keep in mind that in our country, unlike some other countries, but in our country, there is a presumption of innocence. You are presumed to be innocent of the crime of which you are charged until you've been convicted. And so the presumption is that you will not be locked up awaiting your trial. Some people and we have different states have different approaches for this, very clearly pose a threat to society. And if a certain showing can be made, then I have no problem with those people being locked up before trial. But it's really important to keep in mind the equities on both sides. So letting dangerous people out is a threat to the rest of us, and we should all be concerned about that. But it's also incredibly disruptive of somebody's life. There's a lot of empirical evidence that shows that even more than just a couple of days locked up in jail after you've been arrested, people's lives begin to fall apart. They begin to miss payments. Maybe they get thrown out of their housing. They lose their job. A lot of the things that keep people, enable them to be part of a society, to get along well in society, start to fall apart. And if you keep somebody in jail for too long before trial, even if they're ultimately acquitted or they receive some probation or something like that, their life is basically fallen apart. And they're at much greater risk of going out and committing more crimes. Why? Because the entire fabric of their life is unraveled while they were sitting there in jail. And we have to be mindful of that too.
There are some ways that if someone is potentially a danger, they can still be released. We have things like electronic monitoring and pretrial supervision. So people will be let out on a low bond, or maybe it's a high bond and they have money and they're able to post it. And then they are monitored. Someone is making sure that they're coming in and maybe dropping UAs, doing urine tests to make sure they're not picking up the DUI, or have a scram monitor on them that constantly makes sure they're not drinking alcohol, or has a GPS monitor on it to make sure that they can't get near that domestic violence victim that they strangled a few weeks ago, right? So there are ways to allow people out and protect society, but sometimes it gets to the point where it's too dangerous. I have one thing that we haven't really touched on is I looked through my cases, and I would say 75 to 80% of them, my defendant in that case has a prior felony conviction. These are people who are constantly repeating. And there are so many issues as to why they keep doing this, right? Because frankly, when you get put in custody, it's really hard to come out and start your life over again. A lot of the defendants that I see never had a shot, right? Their parents were horrible. They had no money. They were fending for themselves at very young ages. And I'm very empathetic to that, truly. But at the end of the day, if we have a crime where there is a victim, the victim doesn't really care, right? If I were sexually assaulted by a 16-year-old versus a 24-year-old, does that change how it affected me? If it were someone from a lower socioeconomic status and a bad background, no, that doesn't change how that affected me. So I think there's just so much that has to be considered when talking about this type of thing.
I think we should say that we both agree that whether you get out should not depend on whether you have money. I think we both agree on that, right?
Yes, we do.
So that's a common commitment.
Yes. In Colorado, one of the first questions they ask is, can that person post that bail? Because they want them to be able to do it in the most part, but to have some skin in the game so they actually come back to court. That's the real incentive, is either keeping community safe or making sure that they continue to come to court. Yeah, that's a good question.
Just wanted your opinion on ban the box laws. It sounds like a great concept, but just in the last month I've read a couple studies suggesting that because of banning the box, that there's less black males being hired.
Yeah.
Explain what that is.
Yeah. So, ban the box is a concept that says that we shouldn't allow employers to ask about your criminal history. And it's done with the best of intentions to essentially try to ensure that employers don't discriminate against people with criminal backgrounds. But as you say, there's an increasing body of evidence to suggest that when you prohibit employers from asking specifically about somebody's criminal history, then they make even sort of worse inferences. They just basically stop hiring certain demographics, particularly young black males, because they'd say, if I'm not allowed to find out whether you in fact have a criminal history, I'm going to assume that you don't, or not assume that you don't, but I'm not going to take the risk that you might. And sometimes that's not just a matter, it's not purely discriminatory. Certain employers can get in an awful lot of trouble, including civil liability, if one of their employees, does something to harm a customer or something like that. So these are not illegitimate concerns across the board. I am provisionally persuaded that ban-the-box policies, in other words, policies that forbid private employers from asking about a criminal background, probably do more harm than good. But it's not really my area of expertise, and I'm relying on a body of empirical evidence that I think is still accumulating. But if I had to make a snap decision right now, I would probably push back and oppose ban-the-box policies.
I think Clark and I think this is kind of the libertarian in us coming out, right? I think that having information is really important. And this is not my area of expertise either, but you know, if I had a small family business and someone had sexually assaulted a child before, I think I should have that information. That being said, maybe there's another way that we can address this, that we start to normalize. Society can get behind the fact that not all felons are dangerous, horrible people. Most felons are not dangerous, horrible people. They've just made really bad decisions at some point in their life, and that doesn't mean that they're necessarily going to do that again. And I don't know how we get there. Clearly, if you're a felon because you had a heroin problem and it's 10 years later and you've been going to your Narcotics Anonymous classes and you're better, it would be horrible to think that that person could never get a job again. I don't know what the easy solution is, but I'm kind of a free information type of person.
And the market actually has responded. There are actually some employers that are going out of their way to hire people with criminal backgrounds.
That's true.
Even the Koch brothers, if you can imagine, are backing some programs like this. And there's, what's that name of the bread I like, Nikki? Dave's Killer Bread. Has anybody ever seen Dave's Killer Bread? It's really good. But Dave, the guy who's, you know, on the caricature on the package of bread, is himself a former convicted, I don't know what the right terminology is, a person with a criminal history.
Yeah,
and he goes out of his way
conviction.
to hire people who are getting out of prison to work in his bakery. I think it's really touching. I don't know where the microphone is at this point, so. Okay, can we go to the back row here and then we'll come up?
Oh, does she have a question? I have it. So I recently learned that a disproportionate number of former prosecutors have gone on to become federal judges compared to public defenders. Can you talk a little bit more about that and why this impacts social justice or criminal justice?
I'm so
reform?
gratified. Like, that's my study.
Yeah, that's his paper.
You're the first person to ask me about it. So there's this conventional wisdom that the surest path to becoming a judge is to first be a prosecutor, and but no one. So we dug into it, and no one had ever actually tried to study this comprehensively to see if it's really true. So I had a couple of really bright interns that spent the better part of the year looking at the professional background of every sitting federal judge, except for the senior status ones, but every working federal judge, and more than 700 of them. We had to come up with a whole coding mechanism or whatever, but I'll tell you very quickly what we discovered. It is in fact true that federal judges are vastly disproportionately selected from former prosecutors. So a better way to put it would be that the federal judiciary is wildly imbalanced in favor of former prosecutors. It's about 44%, I think, of sitting federal judges were former prosecutors versus 6 or 7% were former defense attorneys. We actually expanded it to look at everybody who in their prior professional background had served as a courtroom advocate for government, including prosecutors, but also other agencies where they're advocating for government in court, and then compare that to people like me, either a criminal defense attorney or someone who had spent their career advocating against government, which is what I did for most of my career. And when you look at that, the ratio is actually 7 to 1. So there are 7 times more judges whose professional background was advocating for government than judges whose prior professional background was advocating against government. Now, am I here to tell you that just because you worked as a prosecutor means you can't be a neutral judge? Absolutely not. I worked for a judge who spent his whole career advocating for government, and he's one of the most libertarian. I mean, I've seen him be really hard on government lawyers. But in the same breath, I will add this. Do you think that our entire system would look exactly the way it does now if we completely flipped those percentages, and if 7 times as many judges were former ACLU and Institute for Justice lawyers and criminal defense attorneys as prosecutors? It would not look the same, I assure you.
So I guess my position on that is I don't know what, and I don't think Clark knows either, what the state statistics on that are.
No,
I can tell you the Denver bench is, right now, especially with the mayor that we have, the governor that we have, the mayor appoints our misdemeanor judges, the governor is going to appoint our felony judges. We're not seeing that. People that are prosecutors that are trying to become judges, it's almost like a strike against you because we are in a very progressive place right now. But I will say that my toughest judges that I've had are former public defenders because they know what's up. They have represented defendants, they know, I mean, and that's obviously just anecdotal, right? Like, I have only interacted with maybe, and worked in front of maybe a dozen to 20 judges, but it's kind of like a known thing in our office that if you're a prosecutor before, you might actually be more lenient than the public defenders as judges. So I don't know how, I think that would be really interesting to try to play out what it would look like if it were, if it were different.
You prefaced the beginning of your discussion by saying that the U.S. has like a 4 times greater incarceration rate than a lot of other Western countries. If you remove the mental illness issue and the drug issue from that number, from the denominator, what would that percentage then be?
I have no idea.
I'm not sure what that means to remove the mental. So I do think we tend to overuse our criminal justice system compared to other countries. I think that's almost certainly true. We have certain demographic issues that other countries don't, that just, in Scandinavia does not have a really huge kind of economic underclass of people who are persistently, sort of abandoned by their parents or whatever it might be. So, but I would say this, one thing that is very different between us and those other countries that we've not talked about is we impose much longer sentences for comparable crimes. So you're going to be in prison for a lot less time in European countries, Canada, Australia, and of course that contributes to the incarceration rate because it's not just how many people come into the system, but it's also how long they stay. And in America, we put people in prison for a lot longer time than they do in those other countries, and that contributes to it as well.
Yeah, I mean, that's my understanding as well, is just based on the stats. We do put people away for longer. I think our DA went and visited Germany and came back, and I think in Germany, you commit a murder, I think they have maxes at like 40 years or whatever, whereas in this country, there's the death penalty. We don't really pursue that in Denver. But if you are convicted of first-degree murder, you go away for the rest of your life. The mental illness question is so insanely complicated because first off, what does mental illness mean? Right. When someone comes into our system and doesn't understand what's happening, they're incompetent at that time, and we cannot do anything in those cases. The only thing we can do is send them to a mental health provider. They might be in custody, they might be out of custody, and that doctor will make a determination as to whether or not that person can actually understand, this is my lawyer, this is what the charges are, right? So if the doctor says this person's incompetent, that means that person doesn't understand it, and the process for that is restoring that person, hopefully to get them to the point where they can understand. Sometimes you can't restore those people. So there's incompetency, and then there's insanity or mental deficits that can actually be considered defenses, because the theory there is they couldn't actually form the culpable mens rea, the mental state, to commit the crimes. And usually the recourse for that is they go to the state mental health hospital for an indeterminate amount of time until those providers determine that that person is safe to society. But then we just have so many more mental health issues, right? Like, just because you're schizophrenic or severely depressed or whatever that is, that's not going to even qualify for any of these things. And I mean, my guess would be most defendants have some sort of mental illness. I mean, I think most of America does at this point. So, right? I mean, if we include depression and anxiety and all that, right? I mean, I think we're to the point now where, I mean, we're just seeing such large amounts of that I don't even know how we would deal with that.
Before we take our last question, I want to thank you all for coming. Ask you to please be careful. It's still snowing out there. If you have cups and any trash, you could really help to take it to the back. And we'll take one last question, and then we'll thank our panels again. Thanks.
So you have done the studies about the origin stories of judges. Are you thinking about or teeing up the rest, looking at their history and the characters of their decision? Is that any kind of data that you really feel that you can get something out of?
I'm not, because I think it would be impossible to come up with a coherent coding mechanism where you try to associate, a particular decision with a particular judge. A lot of legal questions that come up are close calls. I wouldn't, I don't know how you would sort of try to assess whether a judge is or isn't behaving in a consistently kind of pro-prosecutor or pro-defendant manner. Maybe it can be done. I'm skeptical whether or not the results would even be worth it. I think it's just, there's just too much noise in the channel to really make, you know, reliable conclusions about complex legal questions and behavior.
I was hoping you were going to ask Clark if maybe for 1 year he'll go be a prosecutor and see what it's like. Because I think that's the way you change the system, right? You take people who have these beliefs and you go and become a prosecutor. And if you don't like it, you change it from inside. But I know that's not going to happen. And there are a lot of reasons why, and I understand that.
It's nice to be wanted, though. Thank you.
Well, thank you so much.